Students, welcome back. And now in this part, I'm going to delivering my lecture on the last concluding part of today's lecture, that is the international prosecution. International criminal law, or something similar to it, has a very long history. It is closest European precursor before the modern era was the gibellic system that applied in the medieval era. The most notable of the trials that were related to this system was the Peter von Hagen bench in the Brassage in 1474. Although it is status as a legal precedent is highly limited, the issue involved at that trial superior orders, sexual offences, cooperation in the evidence gathering, and beliefs as to the jurisdiction of the court have clear present-day relevance. The purpose of this lectures regarding the prosecution we have discussed, however, is to introduce the modern history of the international criminal prosecutions rather than provide a comprehensive overview of the entire history of the subject. Therefore, we will uh, discuss in the early part of the 20th century at the end of the First World War. So, after the First World War, the Allies set up a 15-member commission to investigate the responsibility for the start of the war. Violation of the laws of war and the war tribunal would be appropriate for trials. It reported in March 1919, determining that the Central Powers were responsible for the starting the war, and that were violations of the laws of war and immunity. It recommended that the high officials, including the Kaiser, be tried for the ordering such crimes and on the basis of the command responsibility. Further to this, commission suggested setting up the Allied High Tribunal with members from all of the Allied countries to try violation of the laws and the custom of the war and the laws of the immunity. This aspect was criticized by the commission's US and Japanese members. The US members said that they knew of no international statute or convention making violation of the laws and custom of the war, not to speak of the laws and principle of the immunity and international crime. The Japanese representative questioned whether international law recognizes a penal applicable to those who are guilty. The majority, however, clearly considered there to be a body of international criminal law, however, one which did not include aggression as a crime. As a result, the Treaty of Versailles provided in Article 227 that the Kaiser was to be publicly arraigned for a supreme offense against the international morality and the sanctity of treaties before an international tribunal. It was never implemented as the Netherlands refused to hand the case over to the Allies, and on the basis that the offense was a political one. Article 228 and 229 of the Treaty of Versailles also provide for the prosecution of the German nationals for war crimes before the Allied courts, including mixed commissions where the victims came from the more than one state. These provisions, however, were never put into practice. Some prosecutions, but far fewer than the Allies wanted, were undertaken by the Germany itself in Leipzig between 1921 and 1923. The proceedings were characterized by the bias towards the defendants, questionable acquittals, and lenient sentences. However, two of these cases later form important proceedings in the international criminal law. So, students, these are the historical facts which rise and which make the states to rethink policy, because when national prosecution and domestic legislation and domestic prosecution has failed to fail to prosecute their nationals or other nationals in their territory because the leniency, the conduct, the behavior of the lenient behavior, and the question of biasness, impartiality, which rise the international which rise the there should be a creation establishment of the international prosecution. So thereafter, and initially two tribunals was created, IST, ISTR. Those were the initial tribunals. Thereafter ad hoc tribunals, which were the Rwanda and Yugoslavia, the court tribunal of the Rwanda and tribunal of the Yugoslavia, which were the ad hoc tribunals. So, but those tribunals and ad hoc tribunals was created for the specific crimes which was committed. But there's a permanent court which we should the world have which permanent court like ICC and ICJ. So thereafter, those court has been created, and the journey of the international criminal law start from the Nuremberg, which now ended at the Hague. So this is the short history of the international prosecution, which starts from the Nuremberg, and now the permanent court has been established in ICC and ICC statute, which cover, and Rome statute also, which cover the jurisdiction of those courts like International Criminal Court, ICJ, International Court of Justice, and Security Council, United Nations, humanitarian laws, which actually now implement the and bind the states regarding the international criminal law. So students, now I'm going to conclude this part of the lecture, which was regarding the national or international prosecution of the international crimes. I hope this series of lecture uh, give you guidelines and help regarding the understanding of the prosecution of the domestic level, national level, and international level regarding the international crimes. So thank you very much, and see you until the next series of the lecture regarding the international criminal law. So now from next lecture, I will